Hello. In this clip from our Justia webinar, How AI Impacts Small and Solo Law Firms, exploring the potential benefits and risks of incorporating AI into practice, Thomas Schack reviews the ethical rules related to artificial intelligence's role in the legal industry. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
All right, we got to talk about the ethical rules when using AI in everyday practice. So, and that's part of our CLE responsibility here today. So, I'm going to run through them, the rules that we should be considering when using AI in your practice. The first is ABA Model Rule 1.1. That's competence. Again, we did a webinar last year that covered a lot of these points, but we really wanted to get into the specifics of AI in this presentation. So you have to understand whatever system you're using, its capabilities and its limitations, if you're going to be using them responsibly. Again, if you ask an AI system, hey, write a brief for me, on this particular case, and here's the facts. Then you're obviously taking an enormous risk, and because you have to be competent in that area. That also means that anything that you utilize from AI, you have to be competent in. You still have to understand it yourself, which is, again, the double check. If you are operating competently and you're checking AI materials that you're using, then you're likely to stay out of trouble with the competence rule. Model Rule 1.6 is the confidentiality of information. I talked to you about the concept of uploading data to certain systems, and I want to just make something perfectly clear relative to that. If you upload the client's information to a storage device that you can then utilize as a closed database, that may be terrific, but you better be certain, not you think, you better be certain that information is not accessible by anybody in the organization that's providing the AI service. It is, you have to keep an eye on data encryption and you have to have the right vendor. I mean, as lawyers, some of us read every single word of a vendor agreement, and some of us just pass by it, and the vast majority of us honestly pass by it on a daily basis. Because we're not going to take the time to read 10 pages that we've either read before or we've authored and written for clients. So, but in this case, you have to be very, very careful, because you have to understand whether or not there's access to your data and what could happen if there is access. Because again, that kid working in their parents' basement, if they're politically disinclined to your particular client, you may well find out on the front page of the Washington Post or the Wall Street Journal exactly what somebody in the company can do if they get access to your data, and it's political. All right, duties to former clients. This is also really important, because as you start to utilize previous cases and client materials, you have to be careful about using their information, the earlier client's information, in which it might create a disadvantage for the former client. It's a little bit technical, right? But you can imagine and basically the thing to do is, once you start utilizing these systems and you're going to be putting information into a closed data system, you should be very, very candid and open, perhaps added to your retainer agreements or to your representation contracts, that their information, which would be used generically, hopefully not specifically, would be used in the future. I mean, a kind of disclosure like that's probably enough, but you should check with your local or with your state bar if you have any questions about that. All right, continuing, we have Rule 2.1, and this is the advisor. You have to provide independent professional judgment and render candid advice in representing a client. Well, you know, you have to be asking yourself the question, am I the advisor here or is the AI system? You know, is it me or is it this other thing? And so once again, another trap that you can fall into is failing to understand that you have to always exercise independent professional judgment. When you're representing a client, period. All right. Model Rule 5.1, responsibilities of supervisory lawyers. This kind of goes back to that example we used from the ChatGPT brief that was filed. Obviously, those of us that have, you know, that either are supervisors or we're, you know, it's our firm or we're partners, if you're in a supervisory position and you're working, you have to make sure that and we already do this, right, with our subordinate attorneys. You know, you have to make sure that they're operating, you know, within a reasonable assurance that they're going to conform to the rules of professional conduct. So let's just change that slightly, and let's say you don't have your associate anymore, but now you have your AI associate. Same thing. You have to, you know, once we get to a point, and we will be at a point not too distant future, likely, that, you know, the AI systems will be able to operate in certain areas as effectively as paralegals and as effectively as research assistants and, in some cases, subordinate attorneys. That's the tidal wave that's coming. And that's the reason that we're all here today, is to try to get out ahead of it and understand that, you know, that if you do replace a human or human work with AI, you have to be very, very cautious about that. All right, Model Rules 5.3, non-lawyer assistants, right? So this is also, you know, kind of a sticky wicket, because we're in a position now where you have an obligation to have an understanding of the AI tools that you're using, right? Because you are getting non-lawyer assistance in that matter. Now the state bars, and I'm sure that the ABAs they're probably all working very diligently right now to review all of these rules. I have no doubt that many, that many will come up with appropriate, at least primary and secondary rules for how you should, you know, how your responsibilities should be handled with AI tools. But again, you own it. You own all of this. All right. So now we're going to move on to selecting and integrating tools into your practice. This is not designed to be extensive. It's just designed to be an example of some of the things that, you know, you can utilize. And I just want to remind everyone that in no way do we endorse any AI system or any research system or anything else. We're not paid by any of them. And so we will maintain our independence. So it's still the wild, wild west. You got to watch out for split sales promises, term contracts, and automatically escalating costs. I mean, you know, again, as small and solo practitioners, each dollar counts, right? I mean, and we don't want to throw money to the wind, and we can't afford to do what some of the big law firms can do, which is, you know, waste resources under certain circumstances. So you got to keep an eye on the promises, right? So you ask a question. We ask this question of a vendor: if we upload our information, will we be able to upload it, and then will we be able to analyze it, scour it? And the answer was, oh, of course. And I said, my response was 50,000 documents, different documents. Yeah, you sure? And, you know, and we're talking about hundreds of thousands, if not millions of pages. And yeah, it can do all of that. Well, we put it to the test, and unfortunately that system, you could only upload, I think 100 files at a time, and the salesperson never said anything to us about it. Now, we don't tell people in advance that we're going to be doing this type of analysis on their system, but we do make sure that that we caution folks about the promises that are made, because again, a promise from a non-lawyer who's in a marketing department of the AI system or an AI firm is really, a big issue. All right. So watch out for those automatically escalating costs too. I mean, it might be free the first week, and then it might be $200 the first year. And then it goes to $200 a month the second year, and then $500 a month the third year. And, and again, you're contracting for these services. So you always want to be careful by focusing on the closed data systems that we talked about, those systems that are only utilizing the data that has been, established to be accurate, right? Or at least has a broad reputation for being accurate. You have to train your staff on how to use AI tools effectively, and you have to have clear policies for data security and client confidentiality. Just like I said, if you're going to be using AI systems, you have to understand who else has access to it, where are the potential pitfalls, and what can you do. All right, so you also have to do a little bit of extra work sometimes on the vendor side with their security measures. Again, if you're uploading client information, there are certain standards that we have to utilize, and you want to be very clear with a vendor. And, one of the ways to handle all these issues is to put them in writing, right? I mean, put them in an email, and then then when you get your response, I mean, it's not that you're going to rely upon it, but at least you'll be able to go back to that organization and say, WTF, how did this happen when you said that you had ABC data security? Again, no system's impenetrable.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.